Good morning, everyone. Can everybody hear me all right? My name's Mike Lynch, and I'm here to talk about some of the legal aspects of end of life. We're going from the spiritual to the mundane. And I think I want to follow up on something that Michael said. A survey was done last year by an organization, you can find it online at caring.com, and they basically found through their survey that well over 70% of the people felt that doing your will, having your plans in order was very important, but less than 40% of the people interviewed had actually done anything. And we're all aware, I think, of the normal documents that are involved. A will, possibly a trust, what I call ancillary documents, power of attorney, medical power of attorney, directive to physicians. We'll talk about a new thing called most, and burial instructions. I'm not going to get into a lot of details about those kind of documents. I want to suggest an approach to planning, reviewing, or maybe updating your documents. And I start with 3 certainties of life. You're going to die. Taxes are important to take into account, no matter the size of your estate, and I'll explain that. And property will pass. Death first. Dan Jenkins was quite a writer, and he was asked at the end of his life, Dan, what do you think you're going to have on your tombstone? And he said, I knew this was going to happen. So we all know it's going to happen. Death is a certainty. I'll talk about taxes. Property. Michael mentioned the fact that if you don't have a will, something's going to happen to your property. You have a will. Everyone in this room has a will, whether you know it or not, because every one of our states has a series of laws called intestacy, the fancy word. You don't have a testament. You haven't left anything to tell people what to do with what you own. And so our state is a little bit more complicated than some states because we have community property and separate property. And I'm not going to get into that. You can talk to your estate planning attorney about what that means and how that all folds out. So everybody's property is going to pass somewhere, somehow. Again, an approach I want to suggest. It's kind of like an examination of conscience. You're preparing to go to talk to an attorney about your plans. And what I suggest you do is take some time, if you're married, sit down with your spouse and talk about who, what, when, why, and particularly what ifs. The first document I want to talk about is a power of attorney, a financial power of attorney. There are sample documents in the back tables of the room that you're welcome to get and look at. A financial power of attorney is where you name someone to take care of financial matters, your financial assets, in the event you're unable to make decisions. You list a person, oftentimes the spouse, sometimes a child, sometimes a financial advisor. You list a person and empower them to take care of these matters. Now, you don't just sign this thing and put it in the file. If you have an account at Fidelity, for example, and you name your spouse as your power of attorney, take a copy to Fidelity, sit down with your advisor, and have it on file. So then, if something happens, there's been an introduction already made. There are different types of powers of attorney. One's called a durable power of attorney, which means that if you become incapacitated, it still is in existence and legally binding. There are some powers of attorney that only come into effect when a certain condition happens that you put into the document. If I go out of the country for 2 months, I'll be back March 31st. I empower this person to make financial decisions if the market plummets. Who would have ever thought? To sell my stocks or bonds, because I'll be in Italy and I'll be quarantined. Medical power of attorney is the second document that is important, and I classify these documents. They surround the will and trust. They're ancillary, but very important and very connected. A medical power of attorney is similar to a financial power of attorney, but here you're appointing someone to make medical decisions for you. Again, oftentimes, husband and wife, spouse is appointed, maybe a child second in line, and you put this on file with your doctor so that if you're brought to in an ambulance to the hospital and your doctor is called, your doctor can say, he's unconscious, doesn't know who is going to make a decision about an operation or procedure, call the wife. It's all set up. So it doesn't just stay in the file. Next is, now this, we talked about a financial power of attorney for assets, financial assets, a medical power of attorney for making medical decisions, now a directive to physician, or sometimes called a living will. This goes a step further, and this anticipates there may be a time when you're suffering from an irreversible condition or a terminal situation, and you're unable to make a decision about what procedures, life-sustaining procedures or not, hydration, nutrition, those type of things, whether they should be administered to you. Now, I'm talking here about the legal aspects. Father Peter's going to talk about the ethical aspects of this. But legally, you can sign this document. I can appoint my wife, and I can say, if I'm in a terminal condition, she has the power to remove life-sustaining machines, procedures, and let me die a natural death if that be God's will. That's what this does. The latest do not resuscitate, I think that's self-explanatory. The one thing about do not resuscitate orders, if you have an out-of-hospital do not resuscitate order, and the fireman comes and you've passed out and you're lying on the living room floor, and you say, here's the order, you may put them into conflict. I tend to not like out-of-hospital do not resuscitate orders. You may need one when you go to the hospital, but there are so many decisions that might have to be made in the event a situation I just described is why I'm personally adverse to them. But the medical orders for scope of treatment, or sometimes called medical orders for life-sustaining treatment. We've talked about the medical power of attorney during lifetime. You need a procedure, you need a medication. Directive to physicians, that's the end of life for terminal conditions or irreversible situations. This newest, at least in Texas, and I think Father Ginn will address this, is an actual physician's order that if death is imminent and you have an irreversible condition, you can sit down with your doctor and you can have an order, not just something expressing your desires or wishes, but an actual medical order that can be presented to a hospital or someone attending you that tells what you want to happen and who you want to make that decision. Finally, in this realm of ancillary documents, there was a question, I believe the gentleman in the back asked about remains and funeral plans and what should happen to your body. In Texas, we have the right to sign a legally binding document appointing someone to make funeral decisions for you if you haven't made them. You can go to Chris or any funeral home and have pre-planning and have that all legally in place, or you can sign a document of the type I've mentioned and appoint someone. I could appoint my wife, Jeanette, to make those decisions for me, and that's legally binding on the person who's appointed and on the people who will administer or take care of the funeral plans. When you go to the estate planning attorney and you've had these questions and answers and you've talked about them and maybe written some notes about them, you're going to then have to decide on the overriding documents, the will and possibly a trust. And here you need to talk about who's going to handle what you have left, your property, when you die. How is it going to be handled? In other words, in what manner? Will it be left outright? Will it be left in a trust? Are there conditions before it passes to someone? All of these type of decisions you can make and you can have them documented. And it's my experience over a lifetime, I've probably revised our own documents. We're into the fourth revision. And they've gone from young children to children in college to children now out of college, married and with families. And our thoughts and decisions about what we want to have happen have changed. So it's important, I think, not only to decide who's going to get what, how are they going to get it outright in trust, etc., and when are they going to get it. I want to talk a little bit about taxes for a minute. And I said taxes are an important consideration. They should be in the picture, and I want to explain why. Our current tax situation allows anyone to give an outright gift to someone of up to $15,000 per year, and there's no tax that on the recipient receiving the gift. You don't have to file any kind of gift tax returns. It's exempt from reporting. It's exempt from taxation. $15,000 a year. So, for example, I've got 5 children. So if I wanted to reduce my estate by $150,000, I could give each one a check in December for $15,000. That's $75,000. I just got the attention of 2 of my children who are in the room. And then in January 1st, I can give another 5 checks for $15,000 a person, another $75,000 out of my estate. Voila, my estate has just been reduced by $150,000. I'm not that demented yet. Estate taxes. We have an historically unusual situation. I practiced, before I retired 15 years ago, I practiced for over 40 years in this area, and I don't think I ever saw the estate tax exemption equivalent, in other words, how much you can die owning without having to pay tax, ever reduced. It has always been increased, 50,000, 75,000, 150, 500, 700,000, etc. It is now $11.4 million per person. That means I could have $11.4 million of my half of the community. Jeanette could have her $11.4 million, I wish, of her part of the community. And we could leave our children $22 billion, no tax. That's good until 2026. I'd like everyone in the room that has $22 million to please see me outside afterwards. That's a very large number. But there's something that's very important about that number, and that's, we love in acronyms, DSU, Deceased Spouse's Unused Exemption. This is like winning the estate tax lottery. A person dies under the current system before 2026. They don't have an $11 million estate. But let's say they have a $1.4 million estate. Okay? If they file the proper, they don't have to file a estate tax return. But if they file proper documentation, that unused $10 million, in my example, can be passed on to the spouse, so that when the spouse dies, they have $10 million from their deceased spouse, and then whatever the tax law allows at the time of the second spouse's death. Again, you say, why? Well, if you look at the tax proposals of Senator Bernie Sanders, he wants to reduce the estate tax exemption equivalent to $1 million. So if you happen to have a spouse that dies before 2026, or if it happened and the law has changed in that regard, who died before 2026, and you file the proper legal papers, you would have, again, in my example, that $10 million additional amount to carry forward when the law changes to be only $1 million. So you could then have $10 million from your spouse, $1 million of your own exemption, $11 million available to avoid tax. Let me talk about this while I'm on there. I want a little bit of interactive with the audience. I want you to take, if you're following my slides, and write on that slide the word basis. B-A-S-I-S. This doesn't have anything to do with the amount that you can die owning tax-free. This has to do with income tax. Let me give you an example. I buy stock for $100. That stock appreciates to $600. I sell that stock. $600 of cash I've received. I paid $100 for it. I have $500 of income that I have to report and pay tax on. I die owning that same stock that I paid $100 for. The estate tax as it currently exists allows that value for tax purposes to be increased to $600. My wife or my estate now sells that stock for $600. No income tax. It is critically, in my opinion, important when a death occurs from an income tax standpoint to have valuation done on all of the significant assets that you own, because that is a very important element of future tax savings. And again, some proposals want to eliminate that and not allow you that benefit, but it is a tremendously helpful benefit. Finally, all property, real estate, artwork, all property that the decedent owns. Yes, it does.
What about qualified plan money?
I'll get to that in just a minute. Thank you. The third thing I want to talk about in this area is something that was just passed in December, and that is what's called the Secure Act. This affects IRAs, retirement plans. It affects literally trillions of dollars. The revenue estimate when Congress passed this is that they will raise over $15 billion in tax by this change in the next 10 years. What happens? I own an IRA. Jeanette owns an IRA. We have 5 children. I'm now past the retirement age, so I'm taking my money out of my IRA. She's taking her money out of her IRA. I die, I leave my IRA to her. She can continue to take, or vice versa, she can continue, I can continue to take that money out over my life expectancy according to the IRS tables. And those tables assume my life expectancy is well past 110 years. I wish, maybe. But, and so you have to take a minimum amount, as most of you may well know, out each year. Now Jeanette dies, and our IRA money passes to our children. Well, our children are in their 50s and 40s. God willing, we won't both die for the next several years, and maybe they'll be in their 60s and 50s by the time we die. Under this new act, they must take all of the money out within 10 years. That's why the acceleration of the withdrawal of this money and the loss of an expanded tax-free earnings capacity produces $15.7 billion estimate within 10 years. There are limited exceptions, and I've listed those exceptions. How does this make a difference? Suppose my children weren't 50 and 40 or 60 and 50. Suppose I leave it to my youngest grandchild, who's now 5 years old. That could continue to pay out a small amount each year until the child reaches majority. And then, say majority is 18, between 18 and 28, let's say I've got, that both of us have together $500,000 that we left to that child. You can just imagine what an 18-year-old could do with $500,000, or a 28 or a 24-year-old who must take that money out within 10 years. It's my belief that if you've got an IRA and you've designated a beneficiary, especially contingent beneficiaries, ours say, for example, mine to my wife, if I die and she's not living, to our children. Those contingent beneficiaries need to be thought out, and if you've left it perhaps in trust, even more reason to go ahead, review your estate with someone who's experienced and can help guide you through it, because it is a significant change in the law, and it affects a number of people. Jerry?
Mike, do the kids then have to pay the tax? They take the money out, but they pay the tax at the time?
they take it out as ordinary income, and to answer this gentleman Buck's question, there's no increase in basis in that, because when you put the money in, you deducted it from your income tax, or your employer deducted it when they put it in if you got it through employment. And so it's ordinary, it's a deduction on the ordinary income going out, so it's taxed as ordinary income coming out, even though it may be in stocks and bonds, something that otherwise you'd think be capital gains. When it comes out, it's ordinary income. Yes. No. I don't talk about that specific issue, Buck. No, I don't. Yes, ma'am.
How does this affect living trusts that are currently in place? Does this new law in 2026 affect that?
This does not necessarily directly affect living trust, but if a living trust is named as a beneficiary of an IRA, for example, it does potentially affect that. You need to really look at that to be sure that the beneficiary designation and the structure of the trust do what you want it to do. And a lot of people would not want that IRA money to come out in 10 years. There is a new, that a lot of people in this area are talking about. There is a possible approach to this if you have a charitable inclination. I said it must come out within 10 years. One way to address this is to take that IRA money, leave it to a charity, no tax there, and then have the charity pay out an annuity to the individual beneficiary over their life expectancy, over their lifetime, or 20 years, whichever is greater, and that's more than the 10 years you're going to get out of the new law. So it's a way to get around the 10-year requirement. Okay, I want to go quickly through 3 illustrations to kind of talk a little shop about how this works. Let's take this example. We've got a young couple, and I've listed their assets, and what might they do with those assets? Well, they've got small children, and they can do the ancillary documents, powers of attorney, directives of physicians, that type of thing. And in this instance, there might be a way to avoid most, if not all, of probate. You could put cars and house and IRAs with the beneficiary designation. You could put all that in joint ownership or designate the spouse as the owner. The first person dies. If it's joint tenancy with right of survivorship, you've got to have that in the legal language in Texas to make it work. With right of survivorship. Don't just say joint owners. Make sure if you're doing something that says joint tenancy with right of survivorship. In my example, most of all, not all the property, could avoid probate. Just pass directly to the surviving spouse. The problem with that, what happens with a second death? The surviving spouse is going to have to do something after the first death. More critical would be mom and dad go away on a weekend in San Antonio, leave the kids with the parents, the grandparents. There's a car accident. They're both killed. And all you've got is everything in joint tenancy, no will. That's a recipe for cost, chaos, and complications. The second would be single individual, limited assets. In this instance, if the individual died without a will, the intestate laws that I mentioned at the beginning would say everything goes half to the parents. If only one parent is alive, half would go to the parents and half would go to the siblings. But you'd have to work through the probate courts with the dependent administration and some costs and, again, some time and complexity in order to get from hither to yon. So a simple will, some joint tenancy documents, and powers of attorney would set this individual up fine. The final example that I want is a little more complicated, and it goes to the idea I talked about, this deceased spouse's unused exemption. Here you've got an estate that both husband and wife are working, quite successful, but they have children, one out of college and others not yet in college, in high school and younger. And here you have a situation where you've got probably together somewhere around a $3 million estate when you take into account the assets as well as the life insurance that's going to be paid. So you've got, if it's all community property, the easy way to say it's $3 million, so $1.5 million is owned by each spouse. If, in the example I talked about earlier, the one spouse died, you've got the estate planning in order, wills, trusts, everything set up properly, but you don't file this document with the IRS to transfer the deceased's unused exemption to the survivor's unused exemption, you've left the survivor, in effect, exposed if the estate tax exemption amount drops because a new administration comes into power. And I think that rather graphically illustrates the purpose and the usefulness. If you don't do anything else, remember your IRAs are going to come out within 10 years after both spouses have passed. Basis is critically important in order to save you some income tax and put you in the best situation after a death. And finally, the unused exemption. I'll leave some time now for questions and answers. No, questions. I don't promise answers. Sir?
So, are you saying that this unused or carry forward exemption now is somehow going to be grandfathered if the law changes?
Exactly.
Is that what the...
If you file the proper documents, yes. The IRS has a specific regulation that's come out that illustrates that it is right on the point of what I just illustrated.
You know the name or the section number of that?
I don't have it right offhand, but you can Google, God bless Google, decedent's unused exemption, treasury regulations. I think it's example 3 in one of the regulations that's come out. Oh, let me just, excuse me, Phil, for just a second. One reason why I wanted to emphasize on this Secure Act and the 10-year payout required now is because we don't know yet. I was at a conference in Miami, in Orlando in January, and the leading expert in this area said it is her opinion that with the law the way it is now, if a trust is named the beneficiary of an IRA and it's not updated, and the beneficiary of that trust is such that that the IRA has to come out within 10 years, the trustee's only choice is to wait 10 years before taking anything out of it. I don't know whether that's going to be the regulation or not, but that's this expert's opinion at this point. I'm sorry, was there a question over here that David, go ahead.
Does this also apply to Roth IRAs?
Yes. Roth IRAs are fine. You leave it to your spouse. Spouse is one of the exemptions. Continue to take it out over life expectancy. But if after your spouse dies, you've left it to your children, they have to take it out within 10 years. It's still tax-free, income tax-free, but it's accelerated, so you lose that deferral period.
They have to take it out, but it's not taxed.
It's not taxed, correct. But it's not earning tax-free while it's in that Roth either.
Mike,
Please.
over here.
Yes. Yes, Phyllis. I'm sorry. I forgot you. Pardon me.
Do you recommend people complete the most document in addition to the medical power of attorney?
Yes, particularly if they're in an irreversible condition or terminal condition. We had a good friend who had neoblastoma and did one of these documents. Let me put it this way. It was very peaceful. The family was very peaceful when everything was done because nobody had to decide differently than the woman wanted it.
But how is that different from the living will?
The living will is simply usually the living will is honored. This just adds a layer of certainty on top of the living will. They're in conjunction with one another. You're now saying that is not only my desire, it's my doctor's order.
Okay.
That's the difference.
Okay, thanks.
And by the way, I think I forget the group, but I think the Medical Association pushed for this to be statute. It's not statutory in Texas now, but they pushed at the last 2019 legislature. They didn't get it through, but I understand they're going to go back at the 2020 legislature and try to get a statutory form for this. Yes, Susan? Dennis, I'm sorry. Thought it was Susan.
On the 2026 estate carryover, you know, you've got to have someone die, though, before 2026 for that to apply. You can't just go file something
No.
now.
I wish we could. We can't. You got to have a death before either 2026, or if the law happens to be changed, usually estate tax changes are made prospective. So if the estate tax amount were to be lowered, I would anticipate it would be as of the succeeding January 1st. But that could come in, like this Secure Act was passed December 19th and became effective January 1st of this year. So it could be a short fuse that you're dealing with if a death occurred in that time. But yeah, you've got to have a death.
And then on the 401k, you're saying that if both spouses die and they leave the 401k to child,
Right.
child has to take it out before 10 years.
Right?
And you're saying that what the child takes out in the 10 years is taxable income to that child?
Oh, yes,
Unless it's a Roth.
unless it's a Roth.
Thank you, sir.
Let me get this straight. The retirement account passes outside of the
Estate?
estate?
If the beneficiary designation shows that. A caution here, I said, be sure you fill in the contingent beneficiaries when you're doing your beneficiary designations at Fidelity or Vanguard or wherever. Because most beneficiary designations, and I had this happen in practice, you say, to my spouse, and you don't fill in the contingent beneficiary designations. It goes to your estate, then you've only got a 5-year time to take it out. 5-year period of time.
So, Mr. Lynch?
Yes.
So are you saying with respect to your home, when the first spouse dies, you should get an appraisal of the home to step up the basis?
Yes.
So then when the second spouse dies, you've bumped it up from when y'all originally purchased it?
Yes. Right now, if you're alive and you have both spouses are alive and you sell your home, if there's gain in the home, you can exclude up to $500,000. If only one spouse is alive, like after a death, that drops to $250,000. So if you have a $100,000 home that's now appreciated to $600,000 after the first spouse dies, you get the valuation and the new tax basis becomes $600,000. You could sell it for $850,000 under the current law and still not be taxed.
So you just need to get a real estate professional and say, it's my professional opinion, this house is worth X dollars on this.
Yes, and put that in your tax file.
Okay, thank you.
And why? Because if you get audited 15 years down the line or 10 years down the line, you've got that already done. Rather than trying to go get an appraisal that has to look back X number of years, it's not going to have the same force.
Mike, do you mean that, this is Cheryl,
Oh, yes, Cheryl.
do you mean that as far as getting an appraisal, like Kara said, a real estate person to tell you what it's appraised at, or do you have to have a qualified appraiser give you that appraisal?
I would, it's a practical question. If we're talking about a $100,000 gain, potentially, I think a letter from a real estate appraiser who says, I'm knowledgeable in the area, da-da-da-da-da, is fine. If you're talking about $1 million step up in basis, I'd go the full boat.
Okay, thank you.
So it's $500,000 exempt now?
$500,000 for a married couple, $250,000 for one, for an individual. Yes, over here.
Yes, in regard to the DNR, I think it's very important for people.
Please.
In regard to the DNR, the do not resuscitate, I think it's very important for people to know that there are actually very specific information that you need to tell hospitals. I'm dealing with this right now with my mother, and I was talking to the hospital about it as I was coming here. They asked me, do you not want her to be resuscitated at all?
Right.
Then there's something as intubation is fine, CPR, shock, pacemaker. So I think all of us need to be very aware what the DNR stands for and what it is, instead of just saying yes or no. Because that's really a huge point, especially because I find, dealing with my mother and her situation, that healthcare professionals are very quick to either say, yes, we're going to do DNR, or no, and they don't realize that as Catholics or Hispanic Catholics, we view death and life very differently. So I think that's a very important point for everybody to take into consideration.
I agree 100%. Read it, understand it, and I want to make one other comment. the directive to physicians, not the DNR, but the directive to physicians, again, there's a form in the back, and there's a form that I prepared and have used called Attachment A. In the directive to physicians, there's a space where it says, list below any limitations that you want to place on someone who has the power to make end-of-life medical decisions. And you can, in my opinion, you can put in there see Exhibit A, and Exhibit A basically is an expression of my Catholic faith, and I want basically my person who's authorized to make these decisions for me to follow the precepts of the Catholic faith in making my end-of-life decisions. Because from a legal standpoint, you can check the box and say, I want nothing. No nutrition, no feeding tubes, nothing in any event. If I'm in a terminal condition or irreversible condition, I want to be removed from everything. Legally, you can do that. Theologically or religiously or however you want to put it from the Catholic standpoint, if you want to have that taken into consideration, you need to tell the person and the doctors, etc., by an attachment or some language that you put into the directive to physicians. Yes, thank you.
The documents you mentioned with the medical power of attorney, the living will, are extremely important documents. And as a nurse and working with hospitals across the country, all too often patients and families will come in and you have one. Yes. Where is it? It's home. It's in my safe deposit box. Please bring it with you. Bring it with you when you go to the hospital. And what's important now is most hospitals now have an electronic medical record.
Yes.
Ask that these documents be scanned into your record. I have done that with mine, and then I have a test when I go back to the hospital. Can you pull it up? By Medicare, they are required to ask you, do you have an advance directive and power of attorney, and they have to check those boxes. And hospitals do have to honor that. Now, we have different areas of healthcare now. We have outpatient settings and clinics. You go to the GI lab. You're going to have your colonoscopy. They should also ask you, do you have one? And they most often will not. And by law, by Medicare, they don't have to honor your advance directive, which I feel is a problem because they're not respecting the patient's rights. So you may come in with a DNR, something goes south, and they will resuscitate you. So that's a dialogue you must have if you're going into an outpatient setting, an outpatient hospital, an outpatient clinic.
Thank you.
The other thing I've done, they're on my phone. They're always with me.
Very good. We've got time for about one or two more questions. Yes, please.
For those who inherit the IRA and have to take it out within 10 years?
Not if you're a spouse.
Well, I know.
I mean, if you fall within any of those exceptions, yes, within 10 years.
But other than the spouse, you know.
Minor children, disabled,
Right.
chronically ill.
If they're still employed, there's no reason why they can't take that money then and put it into a Roth IRA up to the limits, right?
They could do that. They'd have to pay tax on it first when it comes out. But yeah, if they want to reinvest it in that rather than something else, sure.
Yeah.
You mentioned annuitization as a way to get around this, but what happens if it's a life annuity and you're dead, then there's nothing left?
You can have it a life annuity 20 years, so you can at least add on 10 years.
Mike,
Les.
if I'm in excellent health and my wife is making feverish notes on right of survival spouse, would you suggest I consider sleeping in a different room?
For other reasons, I've done that more than once. Michael?
We've got time, I think, for one more question.
Oh, okay.
One more.
Yes.
Is the church going to somebody going to discuss the church's position on the DNR order?
Father Peter's back at the room.
Okay.
It's a good segue. Okay. Wait till after lunch.
Mike, thank you very much.
Thank you.